Welcome to Clause 8, presented by TradeSpace, where the voices of IP come together to talk about the forces shaping the industry today. If you enjoy this show, please subscribe on clause8podcast.com and wherever you listen to your podcasts. While you're at it, a 5-star review goes a long way for us. In today's show, IP Fray's publisher Florian Mueller shares his predictions regarding proposed SEP regulations in the EU.
So I think we should all kind of brace for impact and should assume that something's going to come out of this, and 2025 is probably the year.
And discusses what to watch for as AI reshapes the patent law landscape. And now, here's your host, Eli Mauser.
Today we're joined by the man, the myth, the legend of the patent world, Florian Mueller. He is now the publisher of IP Fray and wrote the false patents blog for, I believe, 13 years. Anybody who cared about standard essential patents in any real way, that was the publication that they cared about. I once asked the head of communications for one of the top research and development companies in the cellular field about what publication he cares about, and I thought he'd say something like Wall Street Journal or something like that. He said, no, false patents blogs. That's what I read, that's what I care about, and that's what I kind of want to influence what it says. So I thought that was very interesting. And when Florian announced last year that he would be moving on from writing for the false patent blogs, I was like, no, I didn't get the chance to interview him for Clause 8. Luckily, he resurfaced and he agreed to do this. So, Florian, thank you so much for joining Clause 8.
Thanks, Eli, for having me and for this incredibly flattering introduction. I think it is, in all fairness, probably correct to say that people with an interest in certain patent-related topics, not all of them, not the whole breadth, but in certain areas, have at some point either seen my writings or have seen me quoted somewhere or mentioned by someone. That's probably true. And yes, so I'm very happy to join you on your podcast, which obviously covers patent law from a far broader perspective than I ever have.
So, since you are based in Europe, I can't help but start talking about the hottest, topic now in the standard essential patent space, at least, is the proposed regulations in Europe. And I guess maybe I'll let you, Florian, summarize your view. What are these SEP regulations all about?
I believe that there are actually issues that could be addressed or should be addressed in Europe, but not in all of Europe. That's where it starts. It's essentially just in Germany that a couple of court decisions may have gone a little bit too far. Now, one of them was by the Federal Court of Justice, which is like the German Supreme Court when it comes to patent law. There's a constitutional court above it, but it rarely ever gets a patent case. And if, then, only from a human rights point of perspective, fundamental rights point of view. And they made a decision a few years ago that since that decision, and already during the build-up to that decision, where some courts already adopted a similar line, over the course of the past 4 or 5 years, only one defendant to a standard essential patent assertion, meaning a 4G, 5G, Wi-Fi video codec patent, in that case a video codec case, has been able to actually defend themselves on the basis of the obligation that the holders of standard essential patents have to license their intellectual property on fair, reasonable, and non-discriminatory FRAND terms. It's plausible and logical that unwilling licensees would be overrepresented among those who get sued. Because obviously the willing ones, if they're very constructive in negotiations, then someone would think twice before unnecessarily suing them if it can be avoided. But it's also plausible that not all of them have actually been unwilling licensees, meaning parties who invoke that FRAND defense, but who never actually do what it takes to conclude a license agreement, who are engaged in holdout, who just simply try to delay this. And there are really these two kinds of extremes. You can have hold up with standard essential patents. If you, for example, hold such a patent, and if you were to obtain an injunction and shut down an entire telecommunications network like T-Mobile, holding a single patent, but unless they implement that patent, unless they have a license to it, which you would then be withholding from them, unless they pay an outrageous amount of money, they might have to shut down their network. And that would be hold up, which in fact, in this extreme form that I just described, has never really occurred. But there have been cases, and there still are cases where certain products cannot be sold in certain markets. So for example, Oppo and its OnePlus affiliate, which is OnePlus is a high-end Android smartphone brand that's quite popular, and Vivo.
So Oppo is a Chinese phone manufacturer, right?
Yes, they are all Chinese. So Oppo and OnePlus are affiliates, and then there's Vivo, which is not an affiliate, but there's some overlap in ownership. And those three Chinese companies, they actually still haven't returned to the German market. They left Oppo in 2022 and I think Vivo in 2023. But generally, I mean, the system by and large is working well. And then there's this issue of hold out, which is that you have some unwilling licensees who do not want to take a license on reasonable terms in order to devalue SEPs, in order to bring prices down. They just delay, they play this delay game until the patent holder may feel, well, this is like, a hopeless case. We're just going to live with the fact that they are unlicensed, or it's going to make them a lowball offer. And those are the two extremes, and those are the two issues. And it's not possible that every single implementer who's been sued, and that's quite a number because there's plenty of such cases in Germany, it's where the vast majority of those cases are sought, that every single implementer of an industry standard who got sued over a patent over the past 4 to 5 years in Germany has actually engaged in holdout. Many plausible, some no doubt about that, but not all of them. And except for one, and that one only defended itself. There was a Turkish TV contract manufacturer named Vestel, and they only defended themselves because there was like a double dipping issue. They had already licensed some patents and they didn't want to pay for them twice. That means there is a lack of balance. There is something that should be improved, but it's not a Europe-wide issue. No, I've never heard anyone, tell these stories about decisions in other EU member states. The EU is 27 countries, and most of them probably no SEP has ever been asserted. If you look at the ones where it has happened, that would be, places like the Netherlands, France, Spain. There have also been injunctions. There have been sales bans. There have been such decisions, but nobody has really alleged that the system was broken and that legislative intervention was needed, much less that it was urgently needed, because they really tried to rush this through the European Parliament. They only took a few months to then adopt a position. Now the Parliament there in the EU does not make the decision alone. It's now in the hands of the EU Council, where the governments of the member states make their decision. They do not have a hard time limit. There's also no discontinuity like in US Congress, so they can sit on this if they want for forever. But still, so my view is that, yes, that there is something that should be improved about SEP enforcement in Europe. And there are, in fact, issues that even SEP holders, I believe, legitimately criticize, that they say they would, in some situations, like to be in a stronger position vis-a-vis companies engaging in holdout. But this proposal that is now on the table, that has already gone through the European Parliament in a first reading, which is not the final and decisive one, but still, that I think is just the wrong way. That's just not the right way to fix these issues. It does not address some of these excesses of German case law in terms of like putting all the burden on the implementer. It does not address the issue that somebody who infringes a single patent in Germany might be forced to license 10,000 patents worldwide. They do not address any of that. Instead, they just want to create an additional layer of bureaucracy. They want to create a new unit in the EU IPO. Now, IPO sounds like, very broad and inclusive. That's Intellectual Property Office, but it is actually the EU Trademark Office.
But I guess the main point is that I guess these implementers were unhappy about what's going on in the German courts, and that kind of ruins some of their leverage during negotiations. One of the interesting aspects of this regulations is, I guess, they became part of the European Union that focuses on the small and medium enterprises. And it was framed in that those were the victims of the current standard central patent regime. I know you covered this very closely. Is there any truth to that, where small and medium enterprises being hurt by the current way, I guess, the standard central patent holders go about licensing their patents?
It's not a rampant problem. There have been a few outlier cases. What certainly does happen is because there's so many SEP holders out there, some of the large innovators in those fields have actually divested parts of their portfolios to some of those smaller entities. And with so many SEP holders out there, somebody will eventually send a demand letter to some smaller company, sometimes maybe not even figuring that it's a very small company not worth going after. In terms of litigation, the smallest company I have personally so far, despite watching the space closely, seen in court defending themselves actually against such an assertion is ABM, which is the German market leader in Wi-Fi routers, and they're just trying to sell the company for €1 billion. So that is not exactly a super small company. And that is, again, like the relatively speaking smallest defendant to a SEP case I have actually ever seen in all of these years of watching it. What I have seen is that, unfortunately, there's a little bit of an incentive for SEP holders to go and approach some of those little guys. And that doesn't mean that they are micro enterprises, but let's say, companies with 30, 40, 50, or $80 million in annual revenues to approach them, since those companies do not have the kind of litigation budget to defend themselves against infringement assertions, which cost millions per patent, and then get them to pay relatively high royalties. And then they want to use those agreements in that whole FRAND debate, which is about especially the ND part of FRAND, non-discriminatory, as comparable license agreements. So they present them to courts and say, now I want someone bigger to pay the same per unit royalty. So I got this little guy to pay $1 per unit. Maybe I license the same patents to Apple or Samsung for 20 cents a unit, but I got the little guy to pay $1 per unit. And now I try to get this from a Lenovo, another Chinese company that acquired American mobile phone icon Motorola Mobility. And then they go and they want to get like $1 per unit on, say, Motorola phones. And that is where there is a little bit of a potential risk. But again, there's no widespread litigation against those companies. The other question is, would this proposal do anything for those small guys? And I don't see that really, because the whole theory there that the EU has for why it would help the little guys is they say, so we're going to put this bureaucracy in place. The EU Trademark Office, called EU IPO, is going to supervise and organize a process where you then have external consultants recommend what the royalty rate should be between two parties. But to first get there, you have to essentially litigate. It is like, an arbitration. Let's put it this way. It's like an arbitration, except that it is not a proper arbitration. It is, you have just one guy and all of this, not a panel. And so you have this cost. And if for example, if like you or I were a SEP holder, and if we felt we had leverage over someone because they have resource constraints, well, what we would tell them is, guys, you can invoke that EU process. You can get that non-binding recommendation. We're going to still go to court when we're done. I mean, it may delay everything by a year or 9 months or something, but after that, we're going to sue you anyway. So then the cost is actually not lower, then the cost is higher. So the whole idea, the whole premise there that the EU Commission has, the Commission is the executive government of the EU, and they make these legislative proposals usually, and like in this case, their whole theory is that when people get that non-binding opinion on what the right royalty rate should be, that they would automatically settle. And instead, actually, since it is non-binding, everyone still has every incentive to litigate. So I don't really see it as being useful.
Maybe I wasn't following this closely. When these regulations came out, they seemed to come out of almost nowhere, right? And also I heard, maybe the SEP holders weren't prepared.
I think some people were really reasonably hit by surprise, because the proper way to do this, the right way to really engage with industry, and of course it's a controversial topic, so you want to listen to both sides if you're a policymaker. The proper way is that you put very specific ideas on the table and say, now I want to get your feedback. Do you think this is helpful? Do you think we should be going in this direction? But that's not what they did. So I even participated in one of those webinar podcast type of things a few years ago, I think it was 2021, where they held a series, talking about SEP issues. It was really more general. It was like, do you have any grievances concerning SEPs? And then they did those online posts during those webinars where anybody who participated which of course was not even a statistically representative group necessarily, could just say, I have a problem with SEPs, or I have no problem, or I think it's going fine, these types of like high level questions. Later they said that this was all part of their consultations, but they did not really tell people, we want to put this friend arbitration type of like pseudo arbitration process in place. They did not tell people that they wanted to delay everything by roughly a year. So the process per se is 9 months, but obviously you then have time that you need in the build up to this. You have time after this before you then go to court and file your regular infringement action. So it's roughly a year that it costs you. They didn't really tell people, this is what we have in mind. Now, what do you think of this? So that's why it surprised everyone. There are indications, because to some extent those EU officials also have to answer freedom of information type of request, and then actually disclose what conversations they had with people. It looks like that some of the implementers knew a little bit more about what the Commission was going to do, or a little bit sooner, but not that much sooner and not that much more.
Oh, that's interesting. So it wasn't that these implementers came with these like wild stack of regulations and said, all right, can you guys run with this? You think people just within the government came up with these like kind of somewhat random ideas?
That's right. So what you have there's an intellectual property policy unit, which is, I don't know, maybe half a dozen people or so. Within the Directorate General, DG GROW, which is the Director General for the internal market, meaning, harmonization across those 27 markets that form the EU market. And that's just one of 24 plus DGs of the European Commission. So you have this small unit, plus maybe a couple of advisors to the commissioner for the internal market, which is a French politician, Thierry Breton. So it was a small group of people. They had an expert group in place. Some of these people were experts, and I think with respect to some, it's debatable whether they were. But that was also a few years ago, and even that was more like, let's just talk at a high level about some ideas, but it was not specifically the kind of thing that they put forward a year ago. And then it leaked. It leaked in late March or so, 2023, and people were shocked. Those of us who deal with these issues all the time could see that some of it just simply didn't make sense. And I think some of it is still there in the current text. I think even the European Parliament hasn't fixed it. So, for example, this notion that you can determine the essentiality to a standard, meaning that if you want to implement the standard, you inevitably infringe the patent, that you can determine it for an entire patent family by looking at a random one. And that outcome is determinative. So if that one is essential, the family is essential. If it's non-essential, the family is non-essential. That's the kind of totally bizarre stuff that no professional who really actually understands this would do. And that is not also what you would find in a governmental proposal if they engage in proper consultation. And so that is one example. There are these types of issues that are just a matter of craftsmanship. It's not even a question of where you stand politically, whether you want to help implementers or SEP holders or both or none. It's just that it's nonsensical.
Is this abnormal that this is how regulations come up in Europe?
It depends, of course, on the field of policymaking. So in some of those higher profile contexts, it would be unthinkable because there would be too much outrage. And in fact, the head of this unit, of this IP policy unit, gave a speech at a conference in Warsaw, the capital of Poland. First, he said that probably everyone in the room knows more about it than he does. And I think he's an economist. And now, I'm not a lawyer by training, to make this very clear, unlike you. So I've been like a de facto law student now for a decade and a half.
You know more than most patent attorneys.
Yeah, great.
So, I guess.
But I mean, so this guy is an economist. He has not followed litigation like me, has not studied law, and just says everybody in the room probably knows more about it. And then he also said, well, we cannot know for sure that this is actually going to be a good thing, but sometimes you just have to take your chances. You have to use your judgment. You just put up this proposal. What I'm saying is almost literally what he said. This is not an exaggeration. So that is not what they normally do. It is also not the usual modus operandi that they would put out a proposal like this, and then you find like a typo or two per page, grammatical errors and all of this. So the whole thing was very poorly crafted in every respect, even formatting errors, where they now in the middle of a paragraph switch to a different font. It's crazy. But unfortunately, they then got some traction in the European Parliament. So I was going to explain, basically that it's a ping pong game that you have between the European Parliament and the European Council. The Council is where the member states' governments send their experts. And those are people there who day in, day out work on patent policy. And some of them may even be, for example, patent attorneys, fully trained patent attorneys. And they have a different perspective. So they are now sitting on this. They got this from the European Parliament, which sort of like kicked the ball forward to them. And the Council now has to decide what to do and when. So the first question is then, how long is it going to take, right? So a lot of people think that maybe during the first half of next year, they could take the next step and say, that this is now the position of the Council. So for the Council to form a position, you need a qualified majority, you need like a supermajority. So out of those 27, you need like 14, but you also then have certain voting rights that are somewhat proportional to population size, and you need like a supermajority. And that is now where the thing stands. In order for them to agree, each of those member states' governments have to make up their own mind. They have to say, this is what we'd like to do. So Germany circulated a proposal which was not even a specific proposal. It was more like, in general, we are in favor. These are some things we'd like to see, but it has to be done right. So they suggested between the lines that there are issues to be addressed. They did not propose how to actually fix them. The next government of the larger countries that may take a position is probably France. People are waiting for them to say something. And then when everybody has actually taken a position, they have to kind of negotiate and see for what type of proposal can be built that supermajority, the qualified majority among them. And when they've got that, then they have to negotiate with the parliament. And I think this could still take a while. This could still undergo some changes. But unfortunately, the dynamics are such that unless they really cannot agree in the Council, unless they really sit on this forever and at some point the thing, just dies, a death by 1,000 cuts, unless that happens, there will be something. There will be some kind of regulation. Now, it could be diluted compared to the current one. It could be that they, for example, say, yes, you do have to enter this arbitration thing, but in parallel, you can keep suing anyway. They could make all sorts of changes that would render it even more pointless than it already is. And then at some point, maybe nobody would stand anything to gain and nobody would stand anything to lose either. It's very difficult to predict.
So you've written about the intense lobbying activity that's going on both sides now. How are the SEP holders doing now? Any advice you would give them about pushing this in the direction that they want?
Yes. So first, I think in either one of those camps, you actually have really a diversity of positions. They have different interests. So for example, among SEP holders, you have those who are more interested in cellular standard essential patents, 4G, 5G, and coming up now 6G. You've got some others who are more interested in the video codecs, some who prefer to license bilaterally directly while others like to go a lot through pools. So in the end, you then also have to find some consensus, reach some consensus within either group. My impression is that SEP holders very accurately pinpoint the issues with this proposal. But unfortunately, that can then also be perceived by some of the policymakers as just being against, as being deniers, not recognizing that there are issues. As far as the implementers are concerned, it seems that there are some who are a little more sophisticated because they've just dealt with SEP litigation and licensing to a far greater extent and over a longer period of time. And they, I think, are much less enthusiastic about this. But what all of those implementers hope to gain from this is that it sends out a signal to the rest of the world, because you already have lobbying activities going on in other places. They are looking at this in the UK. In the US, the thing was folded. They did not, in the end, actually take a new official governmental position on SEPs. There are things going on in Brazil, etc. So China, of course, the question is always, what are they going to do next? So I think some of the implementers primarily just want the EU to do something that suggests there's a problem to be solved and that emboldens maybe policymakers in other parts of the world to then take potentially very far-reaching measures. But this proposal per se, I believe that a lot of the implementers who say they are in favor don't believe that strongly in the merits and value of that thing either. It's just that Politically, it's easier to just say, I agree with what the government proposes. And now let's just all adopt this. So from their perspective, it doesn't make anything worse. But I don't think they seriously believe it's going to be that helpful. And SEP holders, they used to be in a much stronger position in lobbying, especially when companies like Nokia, Ericsson were major also wireless device makers, handset makers, and when they were just much larger companies and represented far more employees than they do now. Or the other development, the other trend is that you have ever more implementers. SEP holders have always been outnumbered by implementers in a way, because there have always been some who implement these standards without seriously contributing to them. But now you have automotive, you have IoT, all sorts of products that where people were not even thinking about connectivity 5 or 10 years ago, now get connectivity, or they need to implement video codec standards. And that's why I think this outnumbering problem for SEP holders in the whole world, it's the same issue, not just in Europe, it's the same in the US or in Brazil. That problem gets bigger and bigger for them. There's just ever more companies who just say, we believe we are paying too much for this. We'd like, to make these SEPs cheaper.
And it's not my original point, but I think somebody else said that obviously if you come up with really good technology and everybody wants to use it, the users are going to outnumber the company that came up with the technology. So I don't think it's a unique issue to SEPs, but I think it makes sense. So what do you think they could do? They're outnumbered. They're being seen as possibly trying to block everything. Is there anything that they could do to kind of change the direction of this?
To change the direction, I think, is like a very tall order. That's very difficult here. But I do think they actually do get some traction with those governmental patent policy experts as they raise some of these legal and practical issues. So there are issues about fundamental rights. There are issues about international agreements like TRIPS, the Treaty on the Enforcement of Intellectual Property Rights at the WTO level. As they raise these issues and they find a more receptive audience among those people there in the council than they did in the parliament. Because the parliament, these people, they deal with everything all the time, with like 10 different fields of policy making on a given day. They don't really have a lot of depth. They don't, even their advisors, and they just, many of them just felt, well, let's just play this political game and pretend that we are now going to salvage the European IoT and automotive industries. But the council people, they are more interested actually in the details of this and in whether it's actually workable. So I think, yes, they do have traction there. But changing the direction, I think, is not going to happen. The only way that this proposed regulation could be prevented from ever, coming into force would be that because of all of these issues on which maybe the member states cannot find a supermajority that says how they want to go forward, that maybe it just takes so long that at some point it dies. But that is not very likely. So I think we should all kind of like brace for impact and should assume that something's going to come out of this, and 2025 is probably the year.
Wow. All right. So I think my takeaway is that SEP holders' best bet now is just to work with those individual policy advisors on the council and try to provide them with a kind of a practical insights about how this regulation would play out. Before you started Post-Patents blog, I guess the way you entered the patent space is actually in a successful lobbying effort of the European Union, and that was when you started the No Software Patents movement, which was ultimately successful. Can you tell us about how did you get involved in that and why did you feel so passionate about it that you kind of devoted yourself to that?
Yeah, that's obviously like, a walk down memory lane. It goes like 20 years back. And certainly my work has evolved in quite a way, because now I'm actually even helping raising funds for litigation. Not SEPs involved actually in that campaign, doesn't matter, but definitely software patents. Now, 20 years ago, I was an advisor to MySQL, some pronounce it as MySQL, an open source database. So a lot of websites actually use that on the back end. And that was a European company at the time, but had received funding from a major US venture capital fund, Benchmark in California. And then a major patent holder that was not particularly friendly to open source at the time, at least, approached them about licensing. And they got scared because if you in that situation get approached by someone who at the time made rather hostile comments at times concerning Linux and other open source technologies, you really don't know what their agenda is, whether they really just want to conclude a license agreement with you or whether they want to go for the jugular. So they got scared. I was one of those who got scared, but by others got even more scared than I did. And then at the same time, the EU was working on a directive on the patentability of computer implemented inventions. So that would be, I would say, the closest thing you would have as an equivalent to this in the US would be the PARA proposal in the Senate, the Patent Eligibility Restoration Act, where Senators Coons and Tillis would like to overrule the Supreme Court's Alice decision. And that is kind of like similar. Now, what the EU at the time was working on was more like codifying the European Patent Office's practice. But the European Patent Office granted a lot of patents that the national courts throughout the EU would actually declare invalid. And a lot of developers, a lot of companies like this MySQL company at the time did not like the idea, because companies like that and I at the time felt that the best way to protect software was this combination of copyright and trade secrets. So you would not, of course, if you're open source and you do make your source code available, otherwise you would not. That would be a trade secret. And then you would just prevent outright copying. While those who actually wanted those types of patents were companies who really just wanted to have this protection of inventions, protection of technical solutions beyond just direct copying. So it was a major fight. I did not start the movement as a whole. I started one campaign, but when I did so, actually others had already been working on it for a few years. My campaign definitely got a lot of visibility. It also got support from companies, including Red Hat, which is now part of IBM, and some European companies. And in that movement, I was among those who said, well, we are not really going to get a European law that would outlaw software patents. We would not get a law that would restrict the scope of patent eligibility to the extent that nothing related to software would get patented. But this proposal here would make things worse for us, so let's fight it. And in fact, we did, as you noted, we did succeed in getting it rejected. The European Parliament at second reading threw it out. It was the first time at that point in EU history. It may still be the only time. I've not tracked it. I've not been tracking it for all of these past 19 years. But in the summer of 2005, the European Parliament voted the thing down, and that's where it died. Nothing happened. They did not reintroduce a proposal. That's what I was doing at the time. I then got involved with some other patent policy initiative the following year, which was basically about a predecessor to what's now the Unified Patent Court in Europe. It was called EPLA at the time, European Patent Litigation Agreement. But after 2006, I got out of this and only got back in 2010 when I launched the FOSS Patents blog.
Yeah. Well, I want to go back to that, the vote which you mentioned, the second reading was overwhelming. I think it was 648 out of 680 voted against it. Why were you so successful? And I guess, what is your takeaway from that experience?
Yeah, so obviously, it would be great if I could just say we convinced 648 out of 680 members of the European Parliament that our position was right. It was a situation in which basically the two sides of the debate reached a procedural agreement. Everybody just said it's better to just kill this thing now, because those who wanted, let's say, a broader scope of patent eligibility than we did, they were concerned that this could, get out of control and go in the wrong direction and become, like an Alice in the legislative form. And we didn't want it because we thought it could go wrong in the other direction. Interestingly, the excuse that the European Parliament used, and what also enabled those politicians who were in favor of computer implemented invention patents to say we're now going to vote it down, is something that I was, in fact, like the driving force behind that part of the campaign, which was earlier that year, the European Parliament formally asked the European Commission to withdraw the existing proposal and introduce a revised one. And that is something that is possible. It's still possible under EU law. It's rarely done. And the European Commission said, we take note of this vote by the Parliament, but we are not under a hard obligation to do this. We're not going to do it. So then the people in the parliament turned it into an institutional issue, and they just an inter-institutional issue, and said, now we're going to pay back to the Commission. Doesn't matter whether we are in favor or not, but the European Commission ignored our call for new proposals, so let's just all vote it down.
I read, tell me this is true, I read you were so successful that the Real Madrid, they needed help with influencing EU policy, and they hired you to consult. Is that
it is funny because it's obviously the world's biggest sports club in terms of like popularity and all of this. I don't know how many fans
and they needed to come to use.
Fans they have. It's really huge. So yes, that was an interesting thing because it was the only non-computer industry, non-information technologies type of thing I ever did professionally. So the situation they faced was that some were trying to game the system in a way. They wanted to persuade the European Commission to authorize, to sort of like give them authorization for certain measures that would have actually adversely affected the competitiveness of the major clubs in Spain and Italy. Because in those two countries at the time, they were selling their television rights, their broadcasting rights individually, meaning that the big clubs would be able to just generate far greater income than the little guys. It could be like a spread of, say, a factor of 10 to 1 or so between Real Madrid and the smallest team in the league. While in the rest of Europe, they had a more socialist type of, more redistributive approach where the league would sell these rights and would then ensure a certain balance where maybe the strongest team in the league would get twice as much out of this overall revenue as the smallest team in the league, but much less of a spread. And in that situation, and at the time, now they are approaching, I think that their revenues in US dollars have already maybe past the 1 billion threshold, or they are very close to it. At the time, they were more like a 300 million euro or dollar company. And they didn't really know what to do and how to deal with this, but I knew them. I knew them just because I had started an online gaming network in the mid to late 1990s and sold it to a Spanish telecoms company. And somebody from that company was in charge of Real Madrid's digital business. And I explained to them the issue. And they just said, well, we don't really know how we can deal with this. Can you just help us out? And I said, okay, sure.
Wow.
This is fun. I'm going to go to Brussels and we're going to fight. That was also successful. The European Commission was working on a white paper, a set of policy recommendations. The European Parliament, before the European Commission took its position, the European Parliament passed a non-legislative resolution, so not formally binding, but still, politically meaningful. And yes, so I actually built a political majority, and people had two completely different reasons why one part of that, our supporters voted for our views and why the other did. So some simply did not want to actually subject this question to EU law. They did not want to have like a uniform European rule. For example, the British Conservatives, the British Tories, they were not yet, at the point of Brexit, but some of them already had this Brexit mindset, and they just said, we want to deal with it in Britain, not in Brussels. And then the others just didn't like it from an economic policy point of view because they said, well, if we allow this in connection with sports, then what's going to happen in other industries? Are people going to ask for the same, for example, with a view to movies, music, newspapers, maybe even in the technology industry? So that was an interesting thing, but it was really like an interlude. It was really just an episode. I then, in 2009, actually worked on a tech issue again in Brussels, which was a merger. It was Oracle acquiring Sun Microsystems, which had acquired that MySQL company I mentioned before. Fought against that. At the time that I got involved, the US DOJ had already cleared the merger on the fast track. But I wrote a paper that was then also quoted, and the decision was published by the Commission, by the European Commission, so one can actually, verify this. They quoted it, multiple times and gave them, some reasons for opposing the deal. The deal in the end went through, but it delayed everything by about 5 months, and Oracle had to make concessions. A couple of years later, I actually worked for Oracle. So they came to me later, like good sportsmen,
they were impressed.
And accepted. Well, back then we hated what you were doing, but now we actually need some help in connection with standards, in fact. And why don't we work together?
I think that's the biggest compliment. When the opposing party wants you to come work for them. I think you mentioned your views on software patents have obviously changed as well. Why did they change?
Well, first, it was a little bit different 20 years ago in terms of what people would want to patent with respect to software than the patents that were obtained at the time or that have a priority date that's 20 years back, they don't even exist anymore, right? They've all expired. So we are talking about different types of technology now. And what I saw is that in practice in Europe, and that was really about that European situation specifically, you don't really see patent holders going after little guys. There was one unfortunate case in the US about in 2011 or so, where there was a non-practicing entity that sent demand letters and started to sue very small app makers. And then Apple in the Eastern District of Texas tried to intervene, and the judge at the time, I don't remember which one of the Eastern District judges it was, but did not really, let Apple help those developers to the extent they would have wanted to. That was the kind of thing that originally had me concerned. It came up again, but it's rare. So it's an outlier. But by and large, it's really about those larger companies using them as bargaining chips and then doing portfolio licensing. And the way I look at it now is really case by case. So I want to see a particular patent. I ask myself, is this like, a legitimate invention? I want to see the arguments, why it should be invalidated. So it's a more differentiated, more nuanced kind of perspective than I had when I just said no software patents at all, with the no software patents campaign 20 years ago.
And you mentioned to me actually that the regulation that you worked on the no software patents, one small piece of it had to do with standard essential patents. And that's what kind of got your interest. And I guess that's why you started FOSS Patents eventually. Can you, I guess, paint the picture about what was the debate like when you started FOSS Patents, about standard essential patents? Why were you so interested and how did it evolve over time of you?
Yeah, well, I now actually have to correct this a little bit because first in connection, it is true that there was one section of that EU proposal in the mid-2000s that dealt with standard essential patents, but I was not particularly active concerning that when I was more interested in this patent eligibility topic than in enforcement.
Okay.
With FOSS Patents, if I had wanted this to be a SEP block, it would have been called Standard Essential Patents block, would have been called maybe FRAND patents, mobile patents, something like that. Yeah. But it was called FOSS Patents, FOSS meaning free and open source software. So that's the history. And that, by the way, is also one of various reasons for which at some point I felt that it was better for me to now do something new and with a new brand and a new positioning and a new design. And that's when I started not only IP Fray, but also AI Fray to talk specifically about AI regulation, and Games Fray, which is about games and mobile apps.
And I guess, you talked about how all these companies' views changed over time. Your own views changed. Is there anything, I guess, that you learn about, these SEP debates? Everybody's so passionate and heated. But then, you look at 10 years later and, they're taking a completely opposite position.
I think you're right that we are going to continue to see companies seemingly switching sides or adjusting their positions or becoming more balanced. It's a normal, I think, process. We talked about now Samsung and Motorola. They are now Motorola belonging to Lenovo now and temporarily to Google. So Google, Lenovo, Samsung, they're firmly on the implementer side. They are in favor of the SEP regulation, as is Microsoft, as is Apple. So they're now all of those companies who were fighting each other over SEPs at the time. They're now all on the same side, politically speaking. I try to be reasonably balanced. So one of my objectives, and I said I'm going to give this a fresh start with the Fray websites, with my Fray media project. There were various ways in which I wanted this to be different from what I did in the past. So FOSS Patents was just like the musings of somebody whose business it was to work as a consultant. And I really mean as a consultant who gave people advice on something, not this kind of, like litigation finance work that I'm doing now, which is more transactional. I wanted this here to be like a media project. And that also means I want this to be more inclusive. I want to reach people on both sides. In a way, I reach them all the time because even those who hated what the positions I took wanted to be in the know anyways. But I'm now really trying hard to fairly summarize the key arguments of both sides. And my take on the EU SEP regulation maybe I've missed something. I don't really know. Of course, I don't know what everybody else ever said, but it's probably a unique one in the whole debate, because I say, yes, I agree with the implementers that the situation in Germany, the way it presents itself, should be addressed. How to address it and how urgently is another question. That's where I may disagree with them. But yes, they do have a point. Something should be done. At the same time, the SEP holders raise very real and objective issues that exist. I may not agree with 100% of their political statements on some of these controversial questions, but as far as these technicalities are concerned, they are 100% right, and the thing is a bad proposal. So, like the SEP holders, I think the proposal ideally should be thrown out, but like the implementers, I think that maybe something useful should be done, and that is kind of like where I see myself now. So I try hard to maintain contacts with sources on both sides, to talk to implementers, to talk to SEP holders, to talk to companies who've got both types of businesses. And I'm always happy to see companies that, for example, say, we have a lot of SEPs and we do want to actually get paid. We want to monetize them, but we also have products and sometimes find ourselves on the receiving end of assertions. I think that is a healthy basis for them to avoid extreme positions. So just last week, for example, Oppo, that Chinese company I mentioned before, they, on the occasion of World Intellectual Property Day, published an IP white paper. Unfortunately, only in Chinese, but at least the press releases, there were two, were in English. And they explained that they hold, so many 5G patents. They are among the world's top 10 patent filers. They've been among the top 10 now for, 5 years in a row, PCT filers. That they now also, of course, want the value of their intellectual property to be recognized. So those are the kinds of developments that I think help make it easier to find solutions. I hope that more companies from one side are going to move a little bit closer to the middle, and then so that they can at least talk to the other side.
On that subject, one of the topics that you've written on IP Fray recently about is Avanci, right? These patent platforms or patent pools that kind of create an efficient market for SEP holders to collect licensing royalties and for licensees to pay them. In their vehicle program, for example, car manufacturers pay, $30 to license for 5G patents per vehicle. The rise of Avanci and so forth. What impact do you think that will have on kind of the SEP debates going forward?
What I see is that some of the implementers portray Avanci and other pools as part of the problem when they are actually either part of the solution or at least neutral. Why do I say at least neutral? Because these pools do not actually preclude contractually their licensors, their contributors of patents, from entering into bilateral agreements. So I find it hard to see why someone would take issue with an option. If you think that the $30 are not fair, well, then just talk to those 50, 60 patent holders who are part of the pool. Talk to them individually. They will have to sue you if you don't pay, and you can sort it out with them. If, however, a pool provides certain transactional efficiencies and fairly splits them among all the stakeholders, meaning SEP holders, implementers, and pool administrators, then the thing works, and I find it hard to take issue with this. Unfortunately, the automotive industry, I think, is worried because the Munich 1 Regional Court, which is the SEP court in Europe and in Germany, and the world's number one SEP injunctions court. I don't think any court has in recent years ordered, even half as many SEP injunctions as that court alone. That one in 2022 had a case where IP Bridge, a Japanese, sort of like almost like a national, like a sovereign kind of like patent licensing firm, asserted a Panasonic patent against Ford Motor Company. Ford was found to infringe the patent. The patent was deemed valid. And then IP Bridge did not make Ford a bilateral offer for, the 10 or 20 or whatever SEP families that IP Bridge holds. They said, you got to take the Avanci license. And the Munich court endorsed this. The Munich court just said, They don't really have to make that offer because some of these other car makers like, Mercedes and others, they've also taken the Avanci license. And that is something that I do not consider proportionate, because the way it worked with Mercedes was that after they took 3 bilateral licenses, Nokia, Conversant, and Sharp, they just took the pool license because they realized that it was just going to be a waste to talk to those 50, 60 companies and sort it out bilaterally and potentially get sued by many of them. But telling somebody you infringe one patent in one country, Germany, because a European patent is essentially a bundle of national patents. So it was like infringing a German patent. And you have to license 70% or plus at the time. By now, Avanci is more like 80% plus, because later, some like Samsung, Huawei, LG, all sorts of companies joined. But at the time, it was at least, say, in the 70% range and maybe 80. To tell them you have to license, say, like 10,000 4G patents worldwide or more, if you are found to infringe one, I think that went too far. But that is not Avanci's fault. The court could have just simply said, IP Bridge, you guys are not going to get your injunction unless you make them a bilateral offer as well, and then they can choose. And if Ford had the choice, we wouldn't have had this debate. That IP Bridge versus Ford case, in fact, is a big part of that whole EU debate. The European Commission people who worked on this proposal, when policymakers they always come back to that decision as if that meant that patent pools are a problem.
What was, I guess, IP Bridge's incentive in not making a bilateral offer and saying, go get the Avanci?
Now, all of these,
they
all of these patent pools, and Avanci, they do not refer to themselves as a pool, they call themselves a platform, but let's say all of these joint licensing programs, of course, have this problem that the pool administrator is not in a position, does not have standing to enforce. They do not hold these patents. So their contributors have to do so. If nobody enforces, then probably no one's ever going to take a license. At least there has to be a credible threat. So they need a certain incentive system where, of course, you will get like your litigation expenses reimbursed if you get somebody to take the pool license. And they may also, credit this in a way with a view to the redistribution of that patent licensing income. So that might have created a minor incentive for IP Bridge to do that. But again, it was not Avanci or IP Bridge who had to make the decision. It was the court's prerogative to decide. And the court should simply have listened to Ford, and Ford just said, we want a bilateral offer. Maybe we'll accept it, maybe we'll reject it, but we want that bilateral offer. And I believe that if you talk about a field like, say, electric vehicle charging, where maybe you have a pool with 4 patent holders holding a total of 5 patent families. Wonderful. Yeah. Then I could see a point in saying you got to take the pool license because we really do not think it is reasonable and efficient that we have to sue you over each of these 5 patent families separately. But if it is a really huge pool, then I think Avanci, in order for their model to work, they don't need that. Mercedes took the pool license because after they lost against Nokia, Conversant, and Sharp, after they had settled with 3, they realized that it was, inefficient. So that's the way in which I believe it should be resolved. Unfortunately, that case is a big part of the debate in the EU. And it's only one court in Germany in one case, but it gets quoted all over.
So one last SEP question. You say you talk to sources on all sides. And I don't know, from my vantage point, Mercedes sells cars for $100,000. It has all these new features dependent on 5G and so forth. Why is $30 such a big deal? Is it because they have the resources to fight against that? Or, I don't know, what is their thinking that they get so worked up over these $30 per vehicle?
There are different angles from which to look at this. So one is, of course, the one that you took, which is the total price of the car. On the other hand, I think they do have a legitimate argument, a valid argument, that they say if they took the same approach to all of the other components, because there are so many of them in a car, then the whole thing would in the end cost a lot more. The $30 are not, however, and that is the other point you made, and that is one on which I completely agree, there's a lot of revenue that they generate on the back of those patents. And that includes even ongoing service charges. So for the first 2 or 3 years, you have mobile data service, and then after that period, you get a letter, and they ask you to pay a subscription fee per year if you want to retain your access to those services.
By the automotive companies, right?
Yeah, everybody does this.
Yeah.
And then they use these, for example, they use wireless technology for customer service, for maintenance purposes. So, for example, it generates revenue, it saves costs all over the place. The $30 indeed are not much compared to this. The other thing that some people, I think those automotive companies, what they do, and I saw that this happened in litigation, like between Nokia and Mercedes, they would like to use smartphone patent royalties for comparable, especially ideally, of course, cheap smartphones, like the $200 type of low-end smartphones, what they pay. But for how long do we actually use a smartphone? For how many years until we replace it? Because we don't get security updates anymore, or because we just want, the coolest, latest and greatest thing, versus how long these cars are in use. I mean, those cars get sold as used cars all over the, on average, I don't know, are used probably for 15 years. And then you also have to sort of divide those royalties, in fact, by that period. You have to look at the incremental revenue. So with a view to all of that, I think it is justified that it may be more than, say, Samsung pays on a smartphone in terms of patent royalties. It's an unfortunate situation because you've got Apple, who it came out in that U.S. litigation with the FTC Qualcomm thing of 5 years ago, where they said they pay Qualcomm $7.50 per phone, and all others combined get less than that. So meaning that they, at the time, were paying less than $15 per iPhone. And that was before 5G, of course, still. You've got Apple with an interest in bringing down that cost. Not because they cannot profitably make an iPhone as a result of this. The iPhone is wildly profitable, as we know. Then you got the car makers who actually generate a lot of income. And they also know that their story is not the best. So what they all do is they point to Internet of Things, IoT, connected devices of all sorts, companies. And now the latest trend, and I wrote about it on IP Fray a couple of days ago, is that there was a European Commission document related to this proposal released on Friday, but it looks like the research that it summarizes is a lot older. They now have this view in Brussels, apparently, that those SEP royalties complicate the fight against climate change. So their concern is that smart meters and similar products that serve a certain purpose in this environmental context could become too expensive to be adopted, or too expensive to even be profitably made in the first place. So they now have this idea that maybe they could use governmental price regulation, which that SEP regulation is not yet there, but it's like a huge step in that direction. They would like to have governmental price regulation where SEP royalties would have to be reduced if a product like a smart meter is somewhat related to the fight against climate change. And so that shows you the mindset that in the end, I mean, you have like the company that stands more to gain from this than anyone else is Apple. But they're an American company. They're one of the richest companies, probably the richest the world has ever seen in the technology field. And they know that maybe the EU is not primarily sympathetic to them. The car makers get more sympathy in the EU. They have some lobbying clout. But in the end, they try to focus the whole discussion on small companies, maybe like 10 million, 20 million euro companies making smart meters, and say, we need to really regulate SEP licensing and enforcement. Otherwise, it's going to be an impediment to the fight against climate change.
So on IP Fray, you're obviously covering a much wider variety of issues related to IP and patents. Any that kind of stand out to you that you kind of are interested in, that you think others should be watching closely as well?
Yeah, I mean, right now, of course, one thing is that I am now helping a US litigation boutique with litigation finance, but I am not so far really writing about litigation finance on my website. Now, I do know, obviously, there are also some of those major technology companies who don't like litigation finance because they know it kind of levels the playing field. It may enable a patent holder to actually afford litigation against them, and they would like to do something about it. But right now, I don't think there's like a big political fight over it that's raging, but we may see that in our lifetime. Clearly, one of the most interesting topics is now this wider impact of artificial intelligence on the patent system and vice versa. I did an article just earlier today, just summarizing that US PTO consultation.
And today's May 1st, 2024. In case
that's right. We are recording this now on May 1st, and just yesterday on the 30th of April, the US PTO started a 90-day consultation on AI. And the interesting thing is that this time around, they've already moved past the question of inventorship. They're now looking at the next set of AI-related questions, which I think are incredibly interesting. One is, what about AI-generated prior art? What does this mean? Should they accept this if it's not human-made? Because you could have those generative AI systems put out billions, if not trillions of documents and publish them on some internet server. Should all of that in the end be deemed eligible as prior art if you're seeking to invalidate the patent, or even during the patent granting process? They're also looking at and want people to comment on the implications of AI for the person of having ordinary skill in the art concept. Because now with AI, making connections across, very disparate fields of knowledge, this question of would I be likely to combine two references might have to be viewed through a different lens. They also say that with a view to those people having ordinary skill in the art, depositors, having access to AI tools, the question is then which ones, and how can the USPTO even know which ones they are? Those are all the kinds of questions they raise that could even affect claim construction. In the end, the question is, how would an expert in that field, a professional in the field, have understood a certain claim term? The answer may be a different one if you have access to AI-based tools that do the research for you and tell you all sorts of things about it. I believe that in the coming years is going to be a way bigger topic than standard essential patent policy, that there's still going to be a big fight over SEPs because it's like a $20 billion a year industry, SEP licensing, but there's a lot of money at stake. But AI is now a trend where you really don't know. I mean, what should they do? And the risk I see is that there could be temporarily some divergence between the world's different patent systems. You could have different rules in place about AI-generated prior art in Japan than in Europe than in the US. So I think, Eli, that is probably for your Clause 8 podcast and for my IP Fray website, and not just for the two of us, but for everybody in the IP community, this impact of AI on this is going to be a big one. And at some point, I believe we are also probably going to see some really interesting patent assertions relating to AI systems. So then we're going to get into the question of patent eligibility of AI software. So generally, like AI and patents, that I think is the next big thing.
I actually interviewed Professor Ryan Abbott from the Davis Project 2 years ago on Clause 8, and he was talking about all these subjects then, and everybody was like, why is he talking about it? But now they're clearly big topics. Is there anything else, any final thoughts you want to share with the Clause 8 audience?
I would say that with a view to not just the SEP-related lobbying, but also, for example, Apple trying to weaken the ITC and all of this, I would just encourage the IP community to understand that the times have changed in the sense that there was a time, say like 20 plus years ago, where IP policy, again, not just SEPs, was made by the experts, talking to professionals, a very small circle, and the wider general public did not chime in. You now have this new environment, and you have more and more policymakers, particularly also in Europe, but not only, who are receptive to arguments made by big tech, automotive, and all sorts of companies, criticizing the system, for example, saying the ITC goes too far, they just, order too many import bans in too many cases where they shouldn't. I would recommend to the community to be a little more careful. I think in the end, some of these overreaching decisions, like the IP bridge versus Ford thing I mentioned from Germany in the SEP context, or maybe I personally, and I have no relationship with Apple, but let me say I don't like that Apple Watch case before with the ITC import ban for some reasons. Those extreme outliers come with a risk that policymakers may in the end overshoot and may then say we have to dial back and we have to sort of like restrict patent enforcement. I think we need to all try to be balanced and need to be more receptive to legitimate concerns made by defendants and implementers to ensure that the system stays strong and healthy.
That's great advice. Florian Mueller himself on Clause 8. Thank you so much for joining. This was a great discussion.
It's been a pleasure and an honor, Eli. Thanks.
Thanks for listening to Clause 8, presented by TradeSpace. If you enjoyed this episode, consider subscribing and leaving a 5-star review wherever you listen to podcasts. You can also follow clause8podcasts.com for more updates.